Hi, and Happy New Year. My name is Doug Hess. I teach political science and policy studies here at Grinnell, and I also study election policy, election administration, and voting rights. So I want to just make a few comments on the elections. I think most people understand that the elections were fairly held and that there were not any serious concerns, at least concerns large enough to call into doubt the results of the presidential election. But I do want to talk a bit about why it is that some people may be attacking the election still and what some of their arguments are. So first of all, it's important to know that there are about 3,100 or more local jurisdictions in the US, meaning counties, townships, etc., that run the elections. They run the elections according to state and federal law, of course, but they manage the elections. And that means that within those jurisdictions, there are, of course, many precincts. And so there are literally tens of thousands of locations in the US where on election day or the days before the election, something could go wrong, implementation failures, technological breakdowns, etc. And so we always know there will be some problems and maybe even some evidence of malfeasance. But the clearest indication that there were not problems significant enough to call into doubt the election is that Republican and Democratic election officials and others, and those who study elections, have said so. Across the country, there's, I think, a very, very small minority of local election officials who have any deep concerns about the elections, and often those concerns are about somewhere else, not their own elections. So by and large, the vast majority of officials in a bipartisan nature have said the elections are fair. Secondly, I want to talk a bit about some rhetoric that some people like Ted Cruz in the Senate and Mayor Giuliani at the rally on January 6th have used. In this rhetoric, they're saying that there are aspects of the elections that have not been reviewed, some problems that have not been investigated because many lawsuits were thrown out on technicalities, they say. And that's disingenuous. And so I want to explain why I think that is. First of all, there were about 60 cases filed by Trump allies after the elections, and these were dismissed by judges appointed by Republicans and Democrats. And these judges often used very harsh language, noting that there was no evidence being brought forward that was necessary to continue the case, and sometimes even saying that there's no legal argument here that's coherent enough for the court to move forward on the case. So those aren't technical issues. You have to have at least an initial argument and offer some evidence that will allow courts to believe a case should progress. Related to that is a doctrine called laches, L-A-C-H-E-S, which I'll just refer to as timing. So in election cases, at least, laches or timing as a doctrine means that if you're aware of some problem, or if you have a dispute with how elections are run, election policy, election laws in your state, the time to bring those up is not after you've lost, but rather when you became aware of them. And in some cases, these lawsuits that were being brought by Trump allies were bringing up policy issues that had been around for some time. So courts take a dim view of the idea that after you've lost an election, you ask the court to turn it over or to say do-over of the election when you could have asked for this issue to have been litigated a long time ago. The second issue is one that's called standing. And this doctrine is complicated, but essentially standing says that or it asks you as a plaintiff, do you have the right to bring this lawsuit in front of this court? So if there's something about a law in New Mexico, let's say it's a law about restaurants in New Mexico, and as an Iowan, I can't bring a lawsuit against that policy unless I go to New Mexico and go to a restaurant and I'm somehow harmed by that law, or unless I own restaurants in New Mexico. I don't have standing to bring that lawsuit. You have to demonstrate, amongst other things, that you've been in fact harmed or could potentially be harmed by this law and have a direct interest. So in some cases, standing was rejected, or some lawsuits rejected on the issue of standing, meaning the wrong people were bringing the cases, perhaps in front of the wrong courts even. Now, I've worked with many civil rights groups on many lawsuits on voting rights over the past 25 years. The map behind me, the blue stickers, indicate some states, some of the states where I've directly or indirectly worked on litigation. The yellow stickers are about places where we provided technical assistance and therefore did not have to litigate. And in all those suits, standing issues come up. The earliest case I worked on in the mid to late 1990s in Illinois related to the National Voter Registration Act, which was signed in 1993. And this issue of standing was very important to that case because the main plaintiff body was a membership organization. And that case, which was appealed, and conservative circuit court ruled that standing was acceptable for membership organization in a voting rights case. That lawsuit actually has been cited dozens, if not hundreds of times since then on issues of standing. And one of our lawyers on that case was actually Barack Obama. All right, so standing is something that civil rights and civil liberties groups do not want to be a threshold that's very, very high. And if it's too high, then people are denied access to justice. But there has to be, as with doctrine related to timing, there has to be some standard, some threshold. Otherwise, courts become clogged with litigation. And litigation becomes a tool for harassing people or driving up cost or attempting to settle with people to avoid cost of litigation. So courts have to be accessible, but also some reasonable policy has to be in place to allow only litigation that has a chance of having any merit being heard. Finally, I just want to briefly mention some issues about election reform. A lot of organizations have been talking about the need to have a different election system where people don't just express a preference for one candidate on a ballot, but they can instead express, for instance, a rank ordering of preferences, or they may be able to express intensity of preferences or a range of preferences in candidates. And I think that's something we strongly need to consider for how we select presidents in the United States, particularly in the primary system. As it currently stands, there could be several candidates who split a majority of the vote amongst them because they have positions that are very similar. And that may lead to another candidate with only 20 or 25% of the vote, for instance, winning by having the plurality of the vote, even though they have far from a majority of the vote. So I think looking at those election reforms is something we need to take much more seriously. There's no perfect system for elections, but I think a system that prevents a candidate with a small slice of the electorate becoming a party's nominee is something we need to avoid in the future. Finally, I think we need to look at the Electoral College, and there are a lot of reform ideas out there. One that's not discussed too much, but that I've been looking at recently, is the notion of expanding the size of the Electoral College so that some of the more populous states have more members in the Electoral College and therefore creates greater equity. Not perfect equity, but greater equity given their size and the amount of power they should have in the Electoral College. And one way to do that without changing the Constitution is simply to add more seats to the U.S. House of Representatives. Congress has not added seats to the U.S. House since Alaska and Hawaii were added to the Union. And my number crunching estimates that if they added maybe 120 members to the House, the Electoral College would therefore, as well as the House itself, provide more equity to populous states. Now, the public doesn't like Congress and they don't like politicians, so they may not like the idea of adding 120 members to the House. On the other hand, we're the third most populous country in the world. We have over 330 million people in the U.S. right now. And I think a U.S. House chamber of 550 members would not be really unreasonable. Anyway, I'll leave those thoughts with you. Thanks for listening, and thanks to the Rosenfield program for organizing this. And I hope you have a good year.